Do you need to be registered to sell newsletters, put out trading signals, or engage in copy trading? Although it's very common on the security side, it's a little more complicated on the derivative side, and we'll go over why. So generally, whenever you're providing somebody commodity trading advice for money, you would need to register as a commodity trading advisor unless you qualify for one of the exemptions. And I went over one of the other exemptions, 4.14A10, in another video. And this one we're going to go over 4.14A9, which is commonly used for people putting out trading signals and newsletters. And if you stay to the end of the video, I'll go over the case that established why that's necessary. So there's two prongs for this. And because it's an or, if you violate either one of these, then you don't get the exemption. So the two things that you can't do if you're putting out trading signals or a newsletter or anything like that is you can't direct client accounts and you can't provide commodity trading advice tailored to the interest of the particular clients. So if you think of a newsletter and it provides general information, it tells everybody the same thing at the same time. If you are doing an electronic version of that, such as a trading signal, and everybody gets the same information, you're telling everyone to buy, you're telling everyone to sell, you're not taking into account anyone's risk tolerance, their portfolio, their net worth, anything like that. You just give everyone the same information electronically. That's the same as putting out a newspaper. And so you would not violate 4.14A9 if that's all you did. The next one is kind of complicated because it says that you would fall afoul of this if you direct client accounts. So if you are putting out trading signals and then you have software that automatically trades that account, that's directing the account. And you could say, well, the software is trading it, not a person, so why would I have to register? Well, you're the one selling the software, so you would have to register because you programmed it and you're putting all this together. And second, it doesn't say trading the account, it says directing the account. And then if you go to the definition of directing, it's actually very broad because it doesn't say, specifically buy or sell. It says agreements whereby a person is authorized to cause transactions to be effected without the client's specific authorization. So if you have software set up and it's causing these transactions to be executed, then that's directing the account. So this part is very important, without the client's specific authorization. So if you are putting out trading signals and then the client individually checks yes or no, take this trade, don't take that trade, that's all right. But if it's trading it automatically, that's going to be problematic. So this part here, without the client's specific authorization, is what it hinges on. So if it's the client making the decision whether to buy or sell the trading signals that they're getting, that's one thing. But if the software is doing it automatically, that's another. And there's ways that you can set it up that would be okay and ways that you can set it up that are not, but it's very fact specific, so I won't go into it. But generally something like copy trading would not be okay. And you might say, well, I know a lot of companies like eToro that do copy trading, and that is correct. They do it for securities, and securities are regulated differently than commodities. So for instance, you can get referrals for friends and family and get commissions on that for people that open up a trading account for securities, but you would not get that for people that open up a trading account with futures. So directing client accounts is very broad. With regard to the second prong, if you're putting out newsletters or trading signals that everyone gets the same information, that's one thing. But if you give different signals to different people based on their risk tolerance or financial circumstances, that turns into particularized trading advice, and that's not okay. And I mentioned if you stick to the end, I would give you the case that this is based on in the weird history. So there was somebody who was putting out these newsletters, and he was sued by the commission because at the time they said that anyone who sells commodity trading advice for money would need to register as a CTA. So he was represented by a civil rights group called the Institute for Justice, and they took this case to court because there is a New York Times case that went all the way to the Supreme Court where the Supreme Court said that you can't have prior restraints on free speech. So if you made somebody take a test and pay a fee and register just to say something, that's a prior restraint on free speech. So he won that. And he was an interesting guy, and he liked to sue the CFTC a lot. So he did win that case, which was Toucher versus Bourne, and then he would go on to. He did win that case, which is Toucher versus Bourne, and whenever you sue a commission like the CFTC or SEC, the plaintiff is generally the first name, and then whoever the chairman is at the time is the second name. So in this case, Brooksley Bourne was the chairwoman, so it's Toucher versus Bourne. And then when he sued again, it was Chairman Brown-Hruska, so it's Toucher versus Brown-Hruska. And then when he sued again, and Chairman Rayner was chairman, it was Toucher versus Rayner. So he's pretty litigious. And he passed away recently, and he passed away in 2009, apparently. But when I was working at the CFTC and we would get comment letters on different rulemakings, he would submit comment letters, and I don't know who paid for his newsletters, but his comment letters were out of this world. So he would put citations to the Bible. He would call me and my colleagues purported staff attorneys. He would use Gothic font like he was sending a letter to Harry Potter. He would cite things that I've never seen anyone cite before besides the Bible, like the 12 tablets, the Magna Carta, and the Magna Charta, which I did not know were two different things. The Bible, the Treaty of 1783, the Northwest Ordinance, what? And he would say unhinged things like, is there some special reason why members of the New York Bar are exempt from prosecution from the unauthorized practice of law? As a member of the New York Bar, I can tell you, yes, there is a special reason. It's because we are licensed as attorneys. And in case you're wondering, he lets you know that he's both sui juris and sui generis. So rest in peace, Frank Anthony Toucher. Anyway, that's it for today. If you got something out of this, just like and subscribe so you'll see future videos. And if you have a question about this, just leave it in the comments. All right, here's my favorite part of the video, the disclaimer. I'm a lawyer, but I'm not your lawyer. Everything here is for education and informational purposes only. It is not legal advice. If you have a specific legal question, you need to talk to your own lawyer about it. Don't rely on anything you've seen here. I am not your lawyer now or in the future, and anything I've said here or written here does not constitute legal advice and does not create an attorney-client relationship between us. That is all. Have a great day, everyone.